Welcome to today's presentation. All right, let's look at this question about the Industrial Disputes Act of 1947. The question asks, on which date did this act come into effect? Now, this is a key piece of legislation that plays a crucial role in regulating industrial relations in India. It was enacted to address issues related to industrial disputes, employment conditions, and workers' rights. The options given are April 1st, August 15th, January 26th, and May 1st of various years. Remember, understanding the historical context of this act helps us grasp its significance in shaping labor laws. So, think about the timeline around India's independence and post-independence industrial policy. The correct answer is April 1st, 1947, which is just before India gained independence, making it a foundational law for industrial relations in the country. This date is important because it marks the start of formal legal regulation in this area, connecting to our overall theme of understanding the evolution of labor laws in India. Today, let's focus on an important date in history. The answer is a 1st April 1947. This date marks a significant turning point, especially in the context of our overall theme, which is about foundational moments in modern history. When we think about this specific day, it represents the official beginning of a new era, a moment when key changes were set into motion. Remember, dates like this aren't just numbers. They symbolize the culmination of complex political, social, and economic developments. So, as we proceed, keep in mind how pivotal moments like April 1st, 1947, help shape the broader narrative we're exploring today. Now, let's look at what the Act considers as industry. Essentially, it's a broad term that covers various types of work and business activities. First, it includes any business, trade, undertaking, manufacture, or calling of employers. So, whether it's a factory, a shop, or any commercial enterprise, it falls under this definition. Secondly, the term also encompasses any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. This means that skilled trades, manual labor, or even specific crafts performed by workers are included too. The key point here is that both these categories are covered, so it's not limited to just one type of activity. That's why the correct answer is both A and B. And just to clarify, the Act does not restrict this definition to government-run undertakings alone. It's much more inclusive. This broad definition helps us understand that the Act aims to protect a wide range of workers and industries, aligning with the overall theme of safeguarding employment rights across different sectors. So the correct answer here is C, both A and. What this really highlights is that in many situations, multiple factors can be at play simultaneously. Instead of looking for a single cause or effect, it's important to recognize that sometimes a combination of elements is responsible. This ties into the overall theme of our presentation, which emphasizes the complexity of real-world problems and the need for comprehensive solutions. By understanding that both options A and B are correct, we can better appreciate the nuances involved and approach issues with a more holistic mindset. Now, let's delve into the definition of a workman under the Industrial Disputes Act of 1947. It's important to understand that not everyone employed in an organization qualifies as a workman for the purposes of this act. Specifically, a workman does not include certain categories of persons. First, those employed in a supervisory capacity who earn wages exceeding a specified limit are excluded. This means that managers or supervisors with higher wages are not considered workmen under this law. Second, individuals mainly engaged in managerial or administrative roles are also excluded. These are typically those who make decisions or oversee operations rather than perform manual work. Third, persons who are subject to military laws, such as the Air Force Act, the Army Act, or the Navy Act, are not included as workmen. This makes sense because their employment and disciplinary frameworks are governed by separate military statutes. So, when we look at the options collectively, those in supervisory roles earning high wages, managerial personnel, or military personnel, they all fall outside the scope of a workman as defined here. Therefore, the correct answer is all of the above. Understanding these distinctions is crucial because it determines who can invoke industrial disputes procedures and protections under the Act. It helps clarify the scope of workers covered and ensures that the law is applied correctly across different employment categories. So, when we look at this question, the correct answer is D, all of the above. What this really highlights is that often multiple factors or options can be correct at the same time. It's a reminder that in many situations, especially in complex fields like this, there isn't just one clear-cut answer. Instead, it's about understanding how different elements come together to influence the outcome. Recognizing that all these options are correct helps us see the bigger picture and avoid oversimplification. This ties into our overall theme of comprehensive analysis and considering all relevant factors in decision-making. Now let's move on to Slide 8, which focuses on a key question regarding the formation of a works committee. The question is, what is the minimum number of workmen required for the constitution of a works committee in an industrial establishment? The options are A 50, B 100, C 150, and D 200. This is an important point because understanding the threshold helps us grasp the legal requirements for establishing a works committee. Essentially, the law stipulates that if an industrial establishment has a certain number of workmen, they are mandated to form such a committee to promote dialogue and cooperation between workers and management. Most importantly, the correct answer here is 100 workmen. So, if an establishment employs 100 or more workmen, they are required by law to set up a works committee. This threshold serves as a crucial benchmark in industrial relations, ensuring representation and communication in larger workplaces. Remember, this requirement ties back to our overall theme of fostering better industrial harmony through structured participation. It's about balancing the interests of both sides and creating a platform for dialogue. All right, so the correct answer here is B, 100. What this really illustrates is the concept of a baseline or maximum value in this context. It's important to recognize that sometimes, when we're dealing with measurements or counts, 100 often represents a full or complete amount. This ties back to the overall theme of understanding limits and capacities within our system. Remember, grasping these key points helps us better analyze data and make informed decisions moving forward. Now, let's look at who is responsible for appointing a conciliation officer. The correct answer is option A, the appropriate government. This means that the government, at different levels depending on the jurisdiction, has the authority to appoint these officers. It's an important point because it highlights the role of the government in facilitating dispute resolution. Option B, the Chief Labor Commissioner, is a common point of confusion, but their role is more about overseeing the process rather than making the appointment. Option C, the High Court, is not involved in appointing conciliation officers. That authority lies outside the judicial system. Finally, Option D, the employer of the establishment, is not responsible for appointing these officers either. This process underscores the government's role in maintaining industrial harmony by ensuring that qualified officers are available to mediate disputes. Understanding who appoints these officers helps us appreciate how dispute resolution mechanisms are structured within our legal framework. So, when it comes to addressing this particular question, the correct answer is the appropriate government. This highlights the crucial role that government bodies play in managing and regulating various aspects of our society. It's important to understand that the appropriate government is the authority responsible for implementing policies, enforcing laws, and ensuring that regulations are followed. This concept is fundamental because it emphasizes that governance and accountability rest with the specific level of government most relevant to the issue at hand. Throughout this presentation, we've been discussing the importance of clarity in roles and responsibilities, especially when it comes to governance. Recognizing the correct government authority helps streamline decision-making processes and ensures that policies are effectively carried out, ultimately benefiting society as a whole. Now, let's take a closer look at what constitutes a board of conciliation. Essentially, a board of conciliation is a mechanism used to resolve industrial disputes through dialogue and negotiation. The key point here is the composition of the board. First, it can consist of a chairman along with 2 or 4 other members. This setup ensures a balanced representation and diverse perspectives during discussions. Alternatively, the board may include a chairman and an equal number of representatives from both employers and workmen. This arrangement promotes fairness and helps facilitate mutual understanding between the parties involved. Another important point is that sometimes the board might consist solely of a chairman appointed by the appropriate government. This usually happens in simpler disputes or when quick resolution is needed. Lastly, in certain cases, the presiding officer of a labor court may act as the board of conciliation. This helps streamline the process by utilizing existing judicial structures. Overall, the composition of the board is designed to ensure neutrality, fairness, and effective communication between conflicting parties, which ties back to our overarching goal of resolving disputes efficiently and amicably. So, moving on to question 7, which asks us about the machinery for the settlement of industrial disputes under the Act. The options are conciliation officer, board of conciliation, court of inquiry, and collective bargaining committee. The question is, which of these is not actually a machinery for resolving disputes? Now, it's important to understand that the Act provides specific mechanisms to help manage and settle industrial conflicts. These include conciliation processes, inquiries, and bargaining committees. For example, the conciliation officer and the board of conciliation are established specifically to facilitate dispute resolution through peaceful means. The court of inquiry is also a recognized body that investigates and reports on disputes. However, the collective bargaining committee is different. While collective bargaining itself is a key process in industrial relations, the committee as a machinery for dispute settlement isn't officially recognized under the Act. It's more of a voluntary or negotiated process rather than an established legal machinery. So the correct answer here is D, collective bargaining committee, because it's not officially listed as a machinery under the Act for settling disputes. Recognizing these distinctions helps us understand the formal structures the law provides to maintain industrial peace and resolve conflicts effectively. All right, so when it comes to the correct answer, it is D, collective bargaining committee. Now, let's break down what that really means. The collective bargaining committee is a key component in labor relations, serving as a dedicated body that negotiates on behalf of workers and management. This committee is crucial because it helps facilitate open dialogue, ensuring that both parties' interests are considered and addressed fairly. By working through this committee, issues like wages, working conditions, and benefits can be discussed transparently, leading to mutually agreeable solutions. This process is at the heart of collective bargaining, which aims to foster cooperation and prevent conflicts. Connecting this to our overall theme, understanding the role of the collective bargaining committee highlights how organized negotiation structures are vital for maintaining healthy employer-employee relationships and promoting workplace stability. When we talk about an award under the Act, we're referring to a formal decision that resolves an industrial dispute. This decision can be either interim, meaning temporary, or final, indicating a conclusive resolution. Now, these awards are made by different authorities involved in dispute resolution. For example, a conciliation officer who works to bring the parties together and mediate. Then there's the Board of Conciliation, which is a panel that helps settle disputes collectively. And finally, we have courts and tribunals like the Labor Court, Industrial Tribunal, or National Tribunal, which have the authority to make binding decisions. So when we consider all these authorities, these different bodies, they all have the power to issue what we call an award. And the most important point here is that, under the Act, an award can be issued by any of these bodies, covering all the key mechanisms for dispute resolution. This highlights the comprehensive approach of the Act in addressing industrial disputes through multiple channels. So, when it comes to resolving certain employment disputes, The correct answer is C, a labor court, industrial tribunal, or national tribunal. These are specialized forums established specifically to handle issues related to labor and employment. They serve as a crucial part of the dispute resolution mechanism, providing a structured and fair environment for workers and employers to seek justice. These tribunals are designed to address matters like unfair labor practices, wage disputes, and other employment-related conflicts. Remember, their role is essential in maintaining industrial harmony and ensuring that workers' rights are protected under the law. This ties back to the overall theme of our presentation, emphasizing the importance of proper legal channels in resolving employment issues efficiently and fairly. Now, let's talk about when a strike is considered illegal. Essentially, a strike becomes illegal if it is started or declared in violation of specific sections of the law. These sections set the legal boundaries for conducting strikes. First, if the strike violates the provisions outlined in Section 22 or Section 23, it's deemed illegal. These sections typically relate to the procedural requirements and the rights of workers and employers. Then, there's Section 10, which often deals with the recognition of trade unions and the procedures for industrial disputes. Violating this section can also render a strike illegal. Next, we have Section 9A, which covers additional legal protections and restrictions around strikes, especially in essential services. Lastly, Section 33 plays a crucial role. It deals with the penalties and consequences of illegal strikes. The key takeaway here is that these sections collectively define the legal framework for strikes. If any strike breaches these provisions, it loses its legal protection, making it an illegal strike. This ties back to the overall theme of understanding the legal boundaries around industrial actions and ensuring they are conducted within the law. So, when you're asked about the relevant section for this particular point, the answer is either Section 22 or Section 23. It's important to understand that these sections often cover similar or related legal provisions, so knowing which one applies can really clarify your next steps. Basically, these sections provide the legal grounding for the situation we're discussing today, and recognizing which one is relevant helps ensure you're interpreting the law correctly. This ties back to our overall theme of understanding legal frameworks and how they guide our actions or decisions. Remember, pinpointing the right section is crucial for accurate compliance and proper application of the law. Let's take a look at the notice period required for a strike in a public utility service. The question here is, how many days notice must be given? Is it 14 days, 21 days, 30 days, or 42 days? This is an important aspect because notice periods ensure that both the workers and the management have enough time to prepare and negotiate, minimizing disruptions to essential services. Typically, for public utility services, the notice period is set to give sufficient time for proper consultation and planning. The most common and legally recommended notice period in such cases tends to be 30 days, as it balances urgency with the need for proper communication. Remember, understanding these notice periods is crucial because they form part of the broader framework of labor rights and industrial relations, especially in sectors that impact the public directly. So, when dealing with strikes, always keep in mind the importance of adequate notice to maintain transparency and fairness. All right, so let's look at this question about the typical duration of a certain process. The correct answer here is B, 21 days. This is a key point because understanding the timeline is crucial for planning and management. Many people might assume it's longer or shorter, but 21 days is generally the standard period we're referring to. It highlights the importance of timing in this context, and knowing this helps us set realistic expectations and schedules. So, whether we're talking about recovery, training, or another process, keeping this 21-day timeframe in mind ensures we stay aligned with best practices and scientific evidence. It's a great example of how precise timelines can impact overall outcomes, fitting into the bigger picture of effective planning and execution. Let's take a look at this principle called last come, first go. Now, this concept is commonly associated with situations like layoffs, where the most recently hired employees are the first to be let go. It's a straightforward idea that prioritizes experience and seniority over new hires when making difficult decisions. When we talk about retrenchment, this principle also often applies. Companies might choose to reduce their workforce by letting go of the newest employees first, to minimize disruption and preserve experienced staff. It's important to understand that this principle can be linked to other terms like lockouts or closures, but primarily, it's most relevant to layoffs and retrenchment scenarios. In the context of our overall discussion on employment practices, understanding this principle helps us see how organizations manage workforce reductions in a systematic, somewhat fair manner, based on the order of hearing. So, as we move forward, keep in mind how these principles influence not just HR decisions, but also employee morale and company reputation. So, when we look at this question, the correct answer is B, retrenchment. Now, retrenchment is essentially a strategy a company might use when facing financial difficulties or needing to cut costs. It involves reducing or withdrawing from certain markets, products, or even cutting back on overall operations. The goal here is to stabilize the business and protect its core activities. This is different from other strategies like growth or diversification, which focus on expansion. In the context of our overall presentation, understanding retrenchment helps us see how companies respond to challenges and how strategic decisions are made in tough times. It's a vital concept because it shows that sometimes stepping back is necessary to move forward more sustainably. Now, let's look at the jurisdiction of the labor court. A labor court has the authority to adjudicate on specific matters, which are outlined in different schedules. These schedules categorize the types of cases the court can hear. Firstly, there's the first schedule, which generally covers disputes related to employment contracts and conditions of service. Then, we have the second schedule, which might include matters such as unfair labor practices or disciplinary actions. The third schedule often deals with issues like wage disputes or grievances related to remuneration. Lastly, the fourth schedule might encompass other specific matters assigned by law or regulation. Understanding these schedules is crucial because they define the scope of the labor court's authority. It helps us know exactly what kinds of disputes can be brought before the court and ensures that cases are handled by the appropriate forum. This classification connects to our broader theme of understanding labor law jurisdiction, knowing where and how different employment-related disputes are resolved. So, in summary, the labor court's jurisdiction is clearly delineated through these schedules, ensuring a structured approach to resolving labor disputes efficiently and effectively. All right, so when we're asked about the relevant schedule in this context, the correct answer is B, second schedule. The second schedule is often a key part of legal or regulatory documents, as it typically outlines specific provisions, rates, or details that are essential to understanding the overall framework. It's important to remember that this schedule supplements the main act or regulation, providing that detailed information that isn't necessarily included in the main body. Recognizing the correct schedule helps us locate precise details quickly, which is critical when navigating complex legal or procedural documents. So, in essence, the second schedule holds that crucial supplementary information that supports the broader structure we've been discussing. Now, let's move on to slide 25. Here, we're exploring the fifth schedule of the Industrial Disputes Act, 1947. This schedule specifically deals with several important matters. First, it covers public utility services, which include essential services like transportation, communication, and power, services that are vital to the public interest. Next, it addresses matters within the jurisdiction of labor courts. These courts handle disputes related to employment, wages, and conditions of service, areas where specialized legal expertise is needed. Third, it covers unfair labor practices. This is a crucial aspect because it defines what constitutes unfair conduct by employers or workers, helping maintain fairness and order in industrial relations. Finally, it deals with conditions of service for which notice must be given before any changes are implemented. This ensures transparency and proper communication between employers and employees regarding employment terms. Connecting all these points, the fifth schedule helps establish a clear framework to manage industrial disputes effectively, balancing the interests of workers, employers, and the public. It's an essential part of our overall theme, maintaining harmonious industrial relations through structured legal provisions. So the correct answer here is C, unfair labor practices. Now, let's talk about what that actually means. Unfair labor practices refer to actions by employers or unions that violate workers' rights or disrupt fair labor relations. This can include things like dismissing employees without just cause, interfering with union activities, or refusing to bargain in good faith. Recognizing these practices is crucial because they undermine the principles of fairness and equity in the workplace. Throughout this presentation, we've emphasized the importance of protecting workers' rights and ensuring a balanced relationship between employers and employees. Addressing unfair labor practices is a key part of maintaining that balance and promoting a healthy, productive work environment. So when it comes to constituting a national tribunal, the key question is, who has the authority to establish it? The options are the appropriate government, the central government, the state government, or the Supreme Court. Now, the correct answer is actually the central government. This means that the central authority has the power to set up such a tribunal. It's important because it highlights how the central government plays a crucial role in establishing independent bodies that can handle specific types of disputes or issues. This aligns with the overall theme of understanding how different levels of government and judicial bodies are involved in the administrative and legal framework. Remember, the idea here is to see how the structure is designed to ensure impartiality and specialization in handling particular matters through these tribunals. The correct answer here is B, the central government. When we talk about authority and governance in this context, it's important to recognize that the central government holds significant power, especially in matters that affect the entire country. This includes setting national policies, managing defense, and overseeing economic regulations. Understanding this helps us see the bigger picture of how power is distributed across different levels of government. Throughout this presentation, we've been exploring the different roles and responsibilities at various levels, and this slide emphasizes just how central the central government is in maintaining national unity and coordination. Let's take a closer look at what a layoff actually means. Essentially, it refers to a situation where an employer is unable or unwilling to provide employment to a worker. Now, this can happen for several reasons, and understanding these reasons helps us grasp the broader context of employment stability. One key reason is a shortage of essential resources like coal, power, or raw materials. When these are unavailable or deplete, production slows down or stops entirely, making it impossible to keep workers employed. Another reason is the accumulation of stocks. If there's an excess of finished goods or inventory that isn't being sold, companies might cut back on production, leading to layoffs. Breakdowns of machinery also play a significant role. When equipment fails and can't be repaired quickly, production halts and workers may be laid off temporarily. And it's important to note that all of these factors, shortage of resources, excess stock, machinery failure, can collectively lead to layoffs. So, in essence, a layoff isn't necessarily a reflection of the company's performance or workforce issues, but often a result of external or operational challenges. Understanding these causes helps us see the interconnectedness of industry operations and employment, which is vital as we explore broader economic and labor themes throughout this presentation. The correct answer here is D, all of the above. What this really emphasizes is that, in many situations, multiple factors or options can be correct simultaneously. It highlights the importance of considering all possible angles and not just focusing on a single aspect. Throughout this presentation, we've seen how interconnected these elements are, and this question underscores that complexity. So, when you're analyzing a problem or making a decision, remember that often, the right answer isn't just one thing. It's a combination of all relevant factors working together. All right, let's look at this question about the provision for protected workmen. Now, the question asks, under which section of the Act is this provision made? The options are Section 33, Section 25M, Section 9A, and Section 10. What's important here is to understand that the concept of protected workmen is specifically addressed in certain sections that aim to safeguard the interests of workers who are vulnerable or in special categories. In this case, the correct answer is Section 25M. This section deals explicitly with the rights and protections given to protected workmen, ensuring they are covered under specific provisions of the Act. Understanding this helps us see how the Act balances the rights of workers and the responsibilities of employers, especially in cases involving vulnerable groups. So remember, when you're dealing with protected workmen, Section 25M is the key section we refer to. All right, so when it comes to the correct answer, it's Section 33. This part is crucial because it clarifies the specific legal provisions we're discussing. Understanding that Section 33 is the key reference helps us navigate the broader legal framework more effectively. It ties into our overall theme of ensuring compliance and understanding the nuances within the law. Recognizing the importance of this section allows us to interpret regulations correctly and apply them in real-world scenarios. So, keep in mind, Section 33 is the anchor point for this particular topic. Let's talk about the concept of retrenchment as defined under the Act. Essentially, it refers to the termination of a workman's service for any reason whatsoever, but it's important to note that this does not include cases where the termination is a disciplinary punishment. In other words, if a worker is let go for misconduct or breach of discipline, that's not classified as retrenchment. Now, there are specific exceptions to this definition, which are quite significant. Firstly, voluntary retirement of the workman. So if a worker chooses to retire on their own, that isn't considered retrenchment. Secondly, retirement on reaching the age of superannuation, which is typically the official retirement age. And thirdly, if a worker's service is terminated due to continued ill health, that's also excluded from the definition. To sum up, when we talk about retrenchment, we're focusing on dismissals that aren't voluntary, age-related, or health-related. Recognizing these distinctions helps us understand the scope of the law and the rights of both employers and employees. This is an important part of our overall discussion on employment law and worker protections. The correct answer here is D, all of the above. And what that really emphasizes is that when we're considering the question at hand, all these options we've discussed are valid and contribute to the overall understanding. It's a reminder that often, in complex scenarios, multiple factors or solutions are involved, and recognizing that all of these elements are relevant helps us develop a more comprehensive perspective. This ties back to our overall theme of holistic analysis, where considering every relevant piece ensures we're making the most informed decisions. Now, let's discuss what an industrial dispute can involve. Essentially, it can arise between different parties involved in the industrial environment. These parties include employers and employers, which might seem a bit unusual at first glance, but can happen in cases of disagreements within management. More commonly, an industrial dispute can occur between employers and workmen, which is often related to issues like wages, working conditions, or other employment terms. It can also happen between workmen themselves, perhaps due to conflicts or disagreements among employees. And importantly, as the slide highlights, such disputes can involve all of the above, meaning conflicts can arise between any of these groups. Recognizing who the parties are is crucial because it helps us understand the nature of the dispute and how best to address or resolve it. This idea ties back to our overall theme of understanding the complexities of industrial relations and the importance of effective dispute resolution. The correct answer here is D, all of the above. Often, when we're considering complex questions, the best approach is to recognize that multiple factors or options can be valid at the same time. This kind of question encourages us to think holistically and understand that issues are rarely isolated. By selecting all applicable answers, we're acknowledging the interconnectedness of the concepts we've discussed. It's a great reminder that in many real-world situations, the solution involves multiple strategies or perspectives working together. So, always keep in mind the broader context, and don't overlook the value of considering all relevant options. Now, let's talk about the timeline for submitting the report of a court of inquiry. Typically, the report should be submitted to the appropriate government within a specific period after the inquiry begins. The key point here is that there are set time limits to ensure timely resolution. The options are 2 months, 3 months, 6 months, or even 1 year from the start of the inquiry. Generally, the standard period is 3 months, which allows enough time to thoroughly investigate and prepare a comprehensive report. It's important to understand this timeframe because it relates directly to the efficiency and accountability of the inquiry process. Staying within this period helps maintain transparency and ensures that the findings are relevant and actionable. So, in the context of our overall discussion on inquiry procedures, knowing these timelines helps us appreciate the importance of promptness in administrative and judicial processes. The correct answer here is C, 6 months from the commencement of the inquiry. What this means is that, once an inquiry is officially started, there is a specific timeframe within which it should be completed. In this case, that period is 6 months. This is an important point because it helps ensure that investigations or inquiries don't drag on indefinitely, allowing for timely resolution and maintaining public confidence. It also ties into the broader theme of efficiency and accountability in the process. Knowing the timeframe helps all parties involved understand expectations and plan accordingly. Now, let's look at a specific type of settlement, one that's reached directly between the employer and the workman outside of formal conciliation proceedings. This kind of settlement, if agreed upon voluntarily, is actually binding on certain groups. First, it's important to understand that such an agreement is binding on the parties involved in making it. That's the employer and the workmen themselves. So, they are directly bound by what they've agreed upon. But the key point here is that this settlement also binds all workmen in the establishment, not just those who might have been involved in the negotiations. This means everyone working there is affected by the agreement. Furthermore, it extends to all future workmen of the establishment. So, anyone who joins the workforce later on will also be bound by this settlement, ensuring consistency and stability in how the workplace is managed. However, it does not automatically apply only to the members of a trade union that was part of the agreement. The binding effect isn't limited just to union members. It's broader, covering all workmen in the establishment. This highlights an important aspect of workplace agreements. They can have wide-reaching implications beyond just the immediate parties. It's a way to promote stability and clarity across the entire workforce, which ties into the overall theme of maintaining harmonious industrial relations. So, in summary, such settlements are binding on the parties involved, all workmen in the establishment and future workmen, but not limited solely to union members. So, when considering who the key parties to an agreement are, the correct answer here is the parties to the agreement. Essentially, these are the individuals or entities that are directly involved and bound by the terms of the contract. Recognizing who these parties are is fundamental because it defines who has rights, responsibilities, and obligations within the agreement. This concept ties directly into the broader theme of understanding contractual relationships and ensuring that everyone's roles are clear from the outset. Remember, identifying the correct parties is the foundation for any enforceable and effective agreement. All right, let's talk about who has the authority to declare an industry as a public utility service. This is a key point because it determines which government body steps in to regulate essential services. Now, the correct answer here is the appropriate government, which typically means the central or state government depending on the context. It's important to note that it's not just the central government alone, nor is it only the state government, although they do have specific roles. And definitely not the labor commissioner, since their role is more about labor issues rather than declaring industries as public utilities. So, in essence, this power lies with the appropriate government authority, either at the central or state level, based on the industry and jurisdiction. This connects to our overall theme of understanding how public utility services are regulated to ensure they serve the public interest effectively. So, when it comes to determining who holds the responsibility in this context, the answer is the appropriate government. It's important to understand that different levels of government, local, state, or central, have their own roles and powers, depending on the specific issue. By identifying the correct governing body, we ensure that policies are effectively implemented and that accountability is clear. This concept ties back to the overall theme of governance and the importance of clarity in decision-making processes. Recognizing the appropriate government helps us streamline actions and achieve better results in public administration. When you want to refer a dispute to a board, court, labor court, tribunal, or national tribunal, there's a specific process to follow. First, your application must be made using the prescribed form, which is usually provided by the relevant authority. But it's not just about filling out a form. You also need to include a statement that clearly outlines a few key points. This statement should specify who the parties involved in the dispute are. That means identifying the people or organizations in conflict. It should also detail the specific matters that are in dispute. What exactly is the disagreement about? Additionally, it's important to mention the efforts both parties have made to resolve the issue on their own. This shows that you've tried to settle things before escalating the matter. All of these requirements, identifying the parties, describing the issues, and showing the attempts at resolution, are crucial because they give the tribunal or court a clear picture of the dispute. And remember, the correct application form and these supporting details are essential for a proper and efficient resolution process. This step is a fundamental part of the overall framework for handling disputes effectively and fairly. The correct answer here is D, all of the above. And what does that really tell us? Essentially, it highlights that each of the options we've discussed plays a crucial role. When we're analyzing complex systems or making decisions, it's rarely just one factor at play. Instead, it's often a combination, multiple elements working together. So, recognizing that all these factors matter helps us develop a more comprehensive understanding. This ties back to our overall theme of considering the full picture, rather than focusing narrowly on a single aspect. It reminds us that a holistic approach is key to effective decision-making and problem-solving. Now, let's look at the criteria for qualifying as the presiding officer of a labor court. Essentially, the key point here is that not just anyone can be appointed to this position. The individual must have substantial judicial experience. Specifically, they need to have been a judge of a high court or have served as a district judge or an additional district judge for a certain minimum period. This minimum period is crucial because it ensures that the person has adequate judicial expertise and experience to handle the complexities of labor court matters. The options range from 2 years up to 7 years, but the correct requirement is that the candidate must have served for at least 3 years as a district judge or additional district judge. So, in simple terms, the focus is on judicial experience, and this experience must meet or exceed that specified period to qualify for appointment as the presiding officer. This requirement ties into our overall theme of ensuring that labor courts are led by qualified, experienced judges who can effectively handle disputes and deliver justice. The correct answer here is B, 3 years. When we look at the typical timeline for this process, 3 years is generally the standard duration. This period allows for thorough planning, implementation, and evaluation to ensure the desired outcomes are achieved. It's important to understand that this timeframe isn't arbitrary. It reflects the complexity involved in making meaningful changes and sustaining them over time. Connecting this to our overall theme, recognizing the appropriate duration helps us set realistic expectations and plan effectively for long-term success. So let's talk about the duty of a conciliation officer. Essentially, their main role is to mediate in and promote the settlement of industrial disputes. This means they act as a neutral party to help both sides come to an agreement without escalating the conflict. It's important to note that they do not adjudicate or decide who is right or wrong. That's not their job. Nor do they issue awards that are binding on the parties. That's typically the role of a tribunal or court. So, when you look at the options, the correct answer is all of the above, but with a key distinction. Their primary function is to facilitate settlement and promote harmony by mediating disputes. Remember, the overall goal here is conflict resolution, and the conciliation officer plays a crucial role in achieving that through mediation, which is less adversarial and more collaborative. Let's take a closer look at the answer here. Mediate in and promote the settlement of industrial disputes. This is a crucial function because it highlights the role of a mediator in resolving conflicts between employers and employees. Mediation involves facilitating communication and understanding between the parties, helping them find common ground. By promoting the settlement of disputes, the mediator encourages a peaceful resolution without resorting to strikes or legal battles, which ultimately benefits both sides and maintains industrial harmony. This process is vital for ensuring smooth industrial relations and aligning with the broader goal of fostering a productive and cooperative work environment. So, in essence, the key point is that mediating and promoting settlement is about actively helping parties reach mutually acceptable solutions, preventing escalation, and supporting stable industrial relations. All right, let's talk about what a lockout actually is. Basically, a lockout happens when an employer temporarily closes the workplace. This could be a strategic move during a dispute or negotiations, but it's important to recognize it as a kind of work stoppage. Now, it's not just about closing the doors. A lockout also involves the employer suspending work, which means employees are asked not to come in and their work is halted. Most crucially, a lockout is a refusal by the employer to continue employing any number of their workers. This is a significant point because it highlights the employer's control in this situation. It's their way of exerting leverage during labor disputes. When we look at the options, all these scenarios, temporary closing, suspending work, or refusing employment, are actually part of what defines a lockout. That's why the correct answer here is all of the above. Understanding this term is key because it ties into the broader theme of labor rights and employer-employee relations. Recognizing a lockout helps us better understand the tools employers might use during disputes and how they differ from strikes, which are initiated by employees. So the correct answer here is D, all of the above. What this really emphasizes is that when we're considering this particular question, each of the options listed plays a crucial role. It's a reminder that in complex scenarios, multiple factors often come into play simultaneously. By selecting all of the above, we acknowledge that no single element is sufficient on its own, but rather, the combination of these aspects provides a comprehensive understanding. This ties back to the overall theme of our presentation, that a holistic approach is essential when analyzing these types of situations. So, always keep in mind that the most complete answer often involves considering all relevant factors together. Let's look at the question on slide 51. It asks, in which cases is a notice of change in conditions of service, as specified in the fourth schedule, not required? Now the options are, first, where the change is in pursuance of any settlement or award. Second, where the workmen are governed by the fundamental and supplementary rules. Third, both A and B. And lastly, neither a nor. The key point here is understanding the exceptions to the requirement of issuing such a notice. Essentially, if the change aligns with a settlement or award, or if the rules governing the workmen already cover these changes comprehensively, then a formal notice isn't necessary. It's important to connect this to the overall theme of ensuring proper communication and adherence to legal and procedural safeguards when making changes to employment conditions. So, in summary, the correct answer is that these specific cases, settlements, awards, or governing rules, exempt us from issuing a notice, highlighting the importance of understanding the legal framework that governs employment relations. The correct answer here is C, both A and. This is a great example of how multiple factors can influence an outcome, and it's important to recognize that sometimes the best answer incorporates more than one element. When analyzing complex problems, we often find that the true solution isn't just one or the other, but a combination of factors working together. This ties back to the overall theme of our presentation, which emphasizes the importance of considering all relevant variables and maintaining a comprehensive perspective. So remember, in many cases, the answer isn't simply black or white, it's a blend of both. When it comes to awards issued by a labor court, tribunal, or national tribunal, there's a clear requirement that these awards must be in writing. But more importantly, they also need to be signed to ensure their authenticity and validity. So, who exactly should sign these awards? Well, the key figures are the presiding officer, who leads the tribunal or court, and the representatives of the parties involved. That means both the employer and the employee or worker. It's crucial to note that the correct answer here is both A and B. So the award should be signed by both the presiding officer and the party representatives. This helps in maintaining transparency and accountability in the decision-making process. Sometimes, people wonder if other officials, like a gazetted officer of the government, should sign these awards. But that's not necessary unless specified otherwise. The main takeaway is that the award must be signed by those directly involved in the adjudication and representation. Connecting this to our overall theme, it emphasizes the importance of proper documentation and procedural correctness in labor dispute resolutions. Ensuring awards are signed by the appropriate parties helps uphold the integrity of the process and makes the decisions legally binding and enforceable. So, when it comes to the correct answer, it is the presiding officer. The presiding officer plays a central role in the proceedings, especially during meetings or debates. They are responsible for maintaining order, ensuring the rules are followed, and facilitating fair discussion. This position is crucial because it helps keep the process smooth and organized. Remember, the presiding officer is the person who oversees the entire session, making sure everyone has a chance to speak and that the agenda is followed properly. This ties back to our overall theme of understanding the roles and responsibilities that keep our meetings effective and orderly. Now, let's look at the key provisions of the Industrial Disputes Act of 1947 related to layoff compensation. Essentially, the Act specifies that a workman must have completed a certain minimum period of continuous service to be eligible for layoff compensation. The options include 6 months, 1 year, 2 years, or 240 days of service in the previous 12 months. The most important point here is the minimum service requirement, which helps determine eligibility. This ensures that only workers with a substantial period of service are entitled to compensation during layoffs, aligning with fair labor practices. Remember, this provision ties into our broader theme of protecting workers' rights and ensuring fair treatment in industrial relations. All right, let's dive into the key point here. The correct answer is B, 1 year of continuous service. When it comes to certain employment benefits or eligibility criteria, the length of continuous service matters a lot. In this case, having 1 year of uninterrupted service is the threshold we're focusing on. It's important to understand that this 1-year mark is often used to determine eligibility for various rights or benefits, such as leave entitlements or service recognition. This concept ties back to the overall theme of understanding employment policies and ensuring fair treatment. Remember, the emphasis is on continuous service, meaning there shouldn't be any breaks or gaps during that period. This ensures that the employee's tenure is genuinely ongoing, which is crucial for many employment rights and benefits. So, in summary, maintaining at least 1 year of continuous service is a key benchmark in many employment contexts, helping to establish eligibility for specific benefits and protections. Let's talk about what constitutes an unfair labor practice on the part of the employer. The question here is, which of these options is considered unfair? First, establishing employer-sponsored trade unions of workmen. This is generally allowed and not considered unfair. Second, encouraging or discouraging membership in trade unions by discriminating against workers. This is where things get problematic. It's unfair because it interferes with workers' rights to freely join or leave unions without fear of discrimination. Third, discharging a worker for filing a complaint or testifying in proceedings related to the act. This is also unfair because it penalizes employees for exercising their legal rights. When we look at all these options together, the correct answer is that all of these behaviors are considered unfair labor practices. This highlights the importance of protecting workers' rights and ensuring that employers act fairly and within the boundaries of the law. These principles are key to maintaining a just and balanced labor environment, which is the overall theme of today's discussion. The correct answer here is D, all of the above. What this really highlights is that when we're considering comprehensive solutions or approaches, it's often a combination of factors that lead to success. Each option on its own might contribute, but together, they create a more effective and robust outcome. This ties back to our overall theme of integrated strategies, understanding that no single element is enough on its own. Instead, the best results come from combining multiple efforts, perspectives, or solutions. So, always keep in mind that the most effective approaches are usually multifaceted and collaborative. Now, let's look at the key point here. The provisions regarding the closure of an undertaking are specifically applicable to an industrial establishment where a certain number of workmen were employed on an average per working day over the past 12 months. This threshold is important because it determines when the law kicks in to protect workers' rights during closures. The question is, what is that minimum number of workmen? Is it 50, 100, 150, or 300? Recognizing this number helps us understand the scope of the law and its applicability to different types of establishments. Remember, this is part of our overall discussion on workers' protections and legal compliance during closures. So, pay close attention to these thresholds as they define when these legal provisions become relevant. And so, the correct answer is a 50. This question highlights the importance of understanding the key data points and how they relate to the overall analysis. Recognizing that the answer is 50 helps us see the specific value within the context of our problem, reinforcing the significance of accurate data interpretation. Remember, grasping these details is crucial for making informed decisions and ensuring the integrity of our conclusions. This final point ties together the entire presentation, emphasizing the importance of precision and clarity in data analysis.